Thanks. Please be seated. Sorry. Good morning. We are on the record in our CV24 0122. As you know, we live stream and record these proceedings, and so when you stand up, please announce your name and the name of your client. You each have a maximum of 20 minutes per side, although you're not required to use all of your time. We do require you keep track of your own time, so if you want to reserve some time, you can let us know, but then it's up to you to track that. Please keep in mind that we've read all the briefing, and we've reviewed the record. We've just come from a conference on this case. And so with that, Counsel, you may proceed.
Okay, good morning. May it please the court, my name is Adam Buck, and I represent the appellant Long M. Nguyen. This case is about the statute of frauds and whether it applies to one of the two transactions that Mr. Nguyen was involved in. The two separate transactions were separated by 10 months. The first, he was asked by Derek and Carolina to find them a house, and then 10 months later, he was asked to help them find a business partner to flip the house. So the real estate transaction was in November of 2020, and the joint venture business partner transaction was in September of 2021. Now, the real estate transaction falls within the statute of frauds, and our argument is the joint venture business partner finder's fee transaction does not. So the real estate transaction, in November of 2020, Derek and Carolina signed a written buyer-broker exclusive employment agreement, and they agreed to pay Mr. Nguyen a real estate commission of 3% or $6,500, whichever was greater. And to earn the commission, he had to locate the property, negotiate acceptable terms with the seller, and then assist the buyer in the transaction. So they found a home in Surprise, Arizona. They negotiated with the terms with the builder. It was a new build. And they signed the purchase contract on November 27, 2020. So as of that date, Derek had equitable title to the property, and Mr. Nguyen had earned his real estate commission.
And just for the record, he was paid that commission?
Yes.
That's the commission he was paid at the end?
Yes.
And he's not disputing any of that?
That's correct.
Okay. And
so
was that the responsibility of the original buyers or jointly with the Stephensons to pay that commission?
Originally, it was just with Derek and Carolina. Then when they did the joint venture, they decided to put them on as additional buyers.
Right. So were they both responsible for that commission?
They both signed off that my client could be paid the commission, yes.
Okay. And did the Stephensons have to sign an agreement in order to be considered a buyer? Because I noticed from the paperwork that your client basically in the addendum contract says that he's representing all buyers.
Yes.
Okay, but there wasn't a written agreement that he was representing the Stephensons?
Yes.
There was or there wasn't?
There was in the real estate transaction.
Okay, but they didn't have any kind of separate agreement that he was representing them as additional buyers. They were just added to the contract and agreed to be bound by that contract and to pay whatever real estate commission was in the contract. But they never had a separate agreement like they did with the original buyers.
Okay, I see what you're saying. No, they didn't sign a buyer-broker agreement.
And yet he was representing them, basically, in the contract it says he's representing them as a buyer.
Yes.
Okay, all right. So
yes.
They were bound to pay or to be jointly responsible for whatever commission was paid.
Yes.
Okay.
And it was paid.
Right, and was paid.
Yes.
Okay.
Just so I'm clear, who paid that? Was that paid by them?
It was paid out of close of escrow when the transaction closed. So
Taylor Morrison, yeah.
Yeah. So essentially the seller pays it out of the money that is paid for the purchase price.
So the seller paid him that commission. None of the buyers did.
Right. they consented to it, because in the buyer-broker agreement, it says that they'll pay it, or if the seller pays it, then they don't have to pay it. But they're bound by it.
Can I ask you, in your original complaint at paragraph 44, you say that Mrs. Stephenson refused to sign the buyer-broker agreement, which was required before your client could collect a finder's fee.
No, a buyer-broker agreement is not required.
I'm looking, do you have your complaint?
No, I don't.
Okay. Because I was just curious if you were saying that somehow they had to sign an agreement for your client to be their agent, or is this some different agreement? You say that it is required before Nguyen could collect a finder's fee. So I'm just having a hard time understanding what...
I think that was supposed to be commission. To be able to collect the commission, they have to sign off on that, because that's required in the real estate rules, is to have a written agreement with the buyer.
And did they do that outside of the purchase contract? Did they sign a buyer-broker agreement? Now I'm confused. Did the Stephensons sign a buyer-broker agreement with your client?
I do not know if they did, but they signed off on the transaction to approve the payment of the commission.
Right, so they signed a contract that basically said, we have this relationship that should have been in writing. Even though we don't have it, we're agreeing to abide by the terms of paying him his commission.
Yes, and there's no dispute that they paid the commission.
Right, but
Yes.
there's also no dispute that they had no agreement, a buyer-broker agreement with your client.
Right, they've signed off and said he could get paid, and he was paid, and so that particular transaction is not in dispute. It's the one 10 months later.
Well, I understand, but I'm just trying to understand the wording that you used in your complaint versus what actually happened.
Yeah.
Okay.
Yeah.
And actually, I have a question. So we've been talking about the contract, which says that Nguyen agrees to represent the buyers. So that covers all 4 buyers.
Yes.
So how is that not an employment agreement under 322151 if he's agreeing to work on their behalf?
Yes, that one is the real estate transaction with the home builder. So that's the transaction that's subject to the statute of frauds, is the purchase from the home builder. Now we have a separate agreement, which is, hey, I need you to find me a business partner to flip this house, which is a different transaction altogether. This is not something that real estate agents typically do in the course of their employment. So they were looking for somebody and said, look, you can get paid a finder's fee. We just need somebody to partner with. So he contacted Mrs. Stephenson and said, hey, I've got this opportunity here. There's $100,000 in equity. You can joint venture. There's immediate equity. And she looked at it and sent a text that said, hey, I'm all in. And then she said,
And you make the argument that because he had placed that restriction on his willingness to provide the contract and the original buyer's contact information, and that she said, I'm all in, you say, well, that is, they basically were entering an oral contract because they knew that if he handed over the information that he expected the $20K finder's fee. But does it work the other way as well? Is that he demanded the $20,000, she says I'm all in, but then without any kind of agreement otherwise, he hands over the information. I mean, is he saying, well, I really didn't need that? Like, we'll figure that out later? Is that really an agreement if they didn't come to terms?
well, the
She
terms,
says a bonus, but she never talks about how much or where it would come from or when it would be due. So the fact that he then, without any more information, says, oh, sure, here's the contract, here's their information, go about your business, and then complains later, does that work both ways?
I don't think so. I don't think she can say, yes, I'll pay you a bonus, and they talk about it. And if we were able to conduct discovery, we could flesh out what the agreement was. We just didn't have a chance to do that.
Well, you had a chance to file a complaint with all the best information that you had factually about why this should survive a 12B6. So what other information could your client flesh out that would bolster your own complaint? I mean, you don't need discovery for that. That's what the complaint was for.
Right. And he said, I need a bonus. I need a finder's fee. And she said, okay, yeah, I'll pay you the finder's fee. My client verbally told her what the finder's fee would be, and she said, okay, I'm all in.
Right, but your argument is that if you were allowed to do discovery, that there'd be more information that would be revealed. And I'm saying, it's your client, it's your claim. What more information does your client have that he could have held back that would bolster that you should have survived a motion to dismiss?
Well, the fact that she agreed to pay a bonus. I mean, there's no dispute. She's not disputing
You already have that in the record. I mean,
Right.
you have a text message, and you allege that there were verbal conversations. I'm not sure.
Yes.
Okay, but I'm
And-
just answering your, if only we had a chance to engage in discovery argument, which I'm finding falls a little flat if it's your claim that you're making, so.
Right, well, she agrees. So here's the thing. She agrees to pay the bonus. She never explains what she meant by that in her responses.
Right, and he never demands it before he hands over the information. He
Right,
never
well, he
demands
did-
any specifics, does he? He doesn't
Right.
say, before I hand this over, let's make sure that we're all agreed on the 20K. Or
Right.
the 20K is you're gonna pay me 10 days after close, or whatever. He went ahead without those.
Right, so he's acting in good faith that she's going to be true to her word and pay a bonus if he gives her the money. They've had a relationship, they work at the same company, and he believed that she would honor her agreement to pay him a bonus when she didn't.
All right, fair enough, thank you.
And so this bringing the buyers outside, joint venture partners outside the scope of what real estate agents do. The fact that the joint venture flips property shouldn't really be a factor in this case, and that's why we cite the Swingle case. You know, Swingle says that you can, in that case they connected somebody with he wanted a 51% interest in a savings and loan. There was nothing in writing. It was all verbal. And then after
Right, but didn't they specifically say that they were endorsing that finder's fee, but then throw in the line, because the subject of the finder's fee did not involve real property or mines within the penumbra of the statute of frauds? So how
Yes.
are we supposed to take that line and Swingle when that's exactly what's happening here?
Well, we're just saying, interpret the statute of frauds narrowly. It's not every transaction that the broker's involved in is not subject to the statute of frauds. Paragraph 7 of the statute of frauds, let me flip to that. Okay. Not finding the language here, but paragraph 7 talks about it has to be related to the purchase and sale of real estate. And so how broadly or how narrowly are you going to interpret that? The argument for interpreting it narrowly is that the statute of frauds could be used to actually perpetrate fraud. You can have representations made, people genuinely saying, yes, I'll pay you if you give me X. They give you X, then they don't pay, and they say, well, the statute of frauds, I don't have to honor that agreement. And so I understand the public policy behind the statute of frauds, but it is very punitive, and so it should be interpreted very narrowly so that we don't inadvertently endorse or facilitate fraud. And that's what the California Supreme Court addressed in the Tenzer case. They talked about let's see. Okay, so they talked about, they said a series of cases have held that an action for fraud cannot be maintained where the alleged fraudulent promise was unenforceable as a contract due to the statute of frauds. And they cite a Kroger case from California that says, look, this is generally what the rule has been. And they call it the Kroger rule. And the Supreme Court of California said they overturned it and said the better rule was found in comment C to Section 530 of the restatement, that a misrepresentation of one's intentions is actionable even when the agreement is oral and made unenforceable by the statute of frauds. They said the broad statement of the Kroger rule is difficult to reconcile with the principle that a party may be estopped to assert the statute of frauds where such estoppel is necessary to prevent fraud that would result from refusal to enforce oral contracts in certain circumstances. And they said it's simply untrue that a plaintiff who undertakes to plead and prove actionable fraud is attempting to get around the statute of frauds. Kroger seems to assume the inability of a jury to distinguish between an unkept but honest promise with one the promisor never intended to perform. And I think that's the important point here. The cases that they cite in their brief involve situation where somebody promised to buy something and then never put it in writing, and they were trying to enforce that agreement. And so they were trying to force them to take action that they didn't want to take. And I understand that. That's different than getting a benefit, making a promise, getting a benefit, and then using the statute of frauds to say, I don't have to pay you. So I think the rationale with the California Supreme Court is, as they say, the better rule. And that's why I think you should interpret the statute of frauds, paragraph 7, very narrowly. Otherwise, it could be interpreted to mean any, or the legislature could have said any transaction that a broker is involved in must be in writing, but they didn't do that. They narrowed it to the purchase and sale of real property. So with that, I think I'll reserve some time.
Can I ask you a quick question? Do
Yes.
you have any case where a lack of a good faith certificate resulted in the sanction that you seek here?
There are no cases that I'm aware of.
Okay, thank you. We'll let you reserve your time.
Good morning.
Good morning.
Ron Ellett, appearing on behalf of Elizabeth and James Stevens, their husband and wife. If I can jump into some of the issues that the court was just asking about, I appreciate counsel's discussion of the California Supreme Court decision, but of course, as we all know, we're not in California, we're in Arizona, and Arizona law from the Arizona Supreme Court is that you cannot reasonably rely on a representation that you contend was orally made in a contract that's prohibited by the statute of frauds. There can be no reliance on those representations because there is no contract if you don't comply with the statute of frauds.
Okay, so walk me through how 44101 applies here. Because Section 7 says, upon an agreement authorizing or employing an agent or broker to purchase or sell real property or mines for compensation or a commission. How was there an agreement here between Mr. Nguyen and the Stephensons to purchase or sell real property?
I want to respond to that, but first pointing out that there's an argument that there's two separate transactions. And so the one transaction that everybody agrees happens was that the Stephensons purchased property that Mr. Nguyen had served as the real estate agent and collected his full commission for. So they signed disclosure statements. All the parties, including Mr. Nguyen, signed disclosure statements that he was their buyer's broker, and they all proceeded with that transaction, and there was a written contract with the original buyers, who were a young couple that were going through a divorce and no longer could perform. There were two transactions, but the two transactions occurred on that day. And that's a matter of public record It's also in the record here because we attached it in support of our reply on the original
The
motion.
double escrow, it
Yeah.
went to them all four, and then it went to your clients.
Right.
But
And
that's
so,
not
no,
the agreement
that's
issue.
not factually correct.
Okay.
And this is
It
important.
doesn't matter, because we're talking about the other agreement, that's the side agreement.
Well, I want to get to that, but the question is how was, the commission was paid on that first transaction. There was an agreement to the original buyers who took title in their own name, not as four folks, but just two. And those people, then, the original buyers turned around and in a double escrow, simultaneous closing, sold it to the Stephensons. There was no commission owing on that second contract. In other words, the second transaction, there was no commission owing. They didn't collect a commission. They're not asserting a commission there. But
Why
as to
does
the
that
other,
matter?
what's that?
Why does that matter?
Well, I was trying to answer your question as to whether or not there was an agreement. The agreement is between the original buyers and Mr. Nguyen, not on that second transaction. Now,
But if we listen to what you're saying, you're almost conceding their point a little bit, that there is a second agreement, like a side agreement, that's not part of the real estate agreement, which gets us out of the statute of frauds.
No, but there is no other agreement. In other words, this finder's fee agreement, is that what you're saying?
Yeah,
There
I would
is
hear
no
what you
finder's
say
fee
about that.
agreement, and there's two reasons why there is, and I think this court's correctly put on this. There is no meeting of the minds when the text was sent that said, "I'll pay you a bonus."
Yeah, but isn't your defense is that it had to be in writing?
Yes, it did.
Right, so, but you're kind of arguing both things. You're saying, to us, you're saying, oh, no, if there was any agreement, it had to be in writing.
Right.
Statute of frauds. But then you're also saying, but there was no chance there was an oral agreement because there was no meeting of the minds. I don't remember seeing that in any of the briefing, that there wasn't a meeting of the minds, or that this wasn't some sort of oral contract, because your whole defense has been that this was statute of frauds.
If there was a contract, it had to be in writing.
Okay.
So we agree with
that.
that completely.
Okay.
Whether or not there was an underlying contract, which I think the court attached to, which your question, Your Honor, I think raised it, which is, but the text says, "I'll pay you a bonus," and he turned over the documents based on a text that says, "I'll pay you a bonus."
But I think what we're talking about is your position, and the whole premise as to why we're here. There was a motion to dismiss because this agreement needed to be in writing.
It did.
But if what you're saying is that there was no meeting of the minds on this finder's fee issue, then why is a motion to dismiss appropriate? Because we're now outside, listening to what you're saying, we're now outside of a real estate agreement, because you said that's all over here. There was no meeting of the minds in this other issue. And so to me, we're in a situation where there shouldn't have been a motion to dismiss, because we don't even know what happened here.
Okay. On the finder's fee, we disagree. One, it had to be in writing. Two, we disagree a finder's fee was ever even discussed. There was actually no factual allegations that any of the things that they say used the finder's fee as the language.
I'm just not sure that's even something we get to, because the court's ruling on the motion to dismiss was that this fell under the statute of frauds.
Okay.
And so it's a simple yes or no. Was the court within its discretion to make that finding? Does an agreement that's been alleged, a finder's fee agreement that's been alleged, can we even go forward to figure out what that is? Yes or no? Because if it needed to be in writing, we can't go forward.
Yeah.
Because both parties are conceding that there wasn't a contract about it.
Yeah.
I think that's all we're answering today, is whether the court appropriately ruled on whether an agreement such as this needed to be in writing. If it did, it wasn't, so she was right. If it didn't need to be in writing, then I think it goes back. And we figure out all the rest of the things you're saying, which is, was there a meeting of the minds? What kind of oral agreement was it? Do we need to do more discovery? That sort of thing. So to me, and correct me if you think I'm wrong, that's the only question we're answering was, did an agreement for a finder's fee in a real estate transaction have to meet the requirements of the statute of frauds? Yes or no?
I agree with you.
Okay, good.
Okay, completely.
Okay.
Okay. There's other issues that we could get into, but I agree with you.
Absolutely, but
This
I don't
had
want
to
to
be in
muddy it.
writing. Why did it have to be in writing?
Right.
Because the alleged agreement related to the sale of and purchase of real estate.
But you just told us that the sale and purchase of real estate went forward without anything to do with that agreement, that process was started, executed, and finished with nobody complaining about what happened in that transaction. That was completed. So how is this also something that had to facilitate the sale of real estate?
Because the allegation here is that they needed to bring in additional buyers, which we can, that's correct. That part of the story is true. They needed to bring in additional buyers because the original buyers were going through a divorce and could not qualify. So they needed to bring in another purchaser. And they brought in James and Elizabeth Stevens as the purchasers for the real estate. So bringing them in is the agreement that they're claiming is a finder's fee agreement.
But hold on a second, because I got a little bit confused back when you started this, and thank you for hanging in there with us. But you said that the original transaction for the home closed without the Stephensons being on it, that the original purchasers closed on that themselves without your clients being co-buyers.
Well,
Is that true or not? Did it close just with the original buyer's name on it?
It was a simultaneous transaction, so it couldn't have closed without the other transaction simultaneously closing, because the money was coming from the Stephensons, poured through into the other. So that's what a simultaneous transaction means. So it took the Stephensons to be in there to make it happen.
Okay.
And so bringing the Stevens in saved this deal,
Right.
and it allowed the deal to go forward.
Okay.
It saved Mr. Nguyen's commission. It produced some benefit for the original buyers, and the Stevensons, who put in all the money to actually buy the property, took on the risk and eventually did make some money.
Great.
So,
Thank you for clarifying that.
so it absolutely required them. The deal was dead without them.
Right,
Okay? That's why they were brought in.
right.
Okay, but
So-
that still brings me back to my underlying question of I'm really grappling with how the statute of frauds applies to the agreement between Mr. Nguyen and the Stevensons. Just the fact that there's underlying real estate purchase, how does that qualify under, real estate employment agreement and then statute of frauds?
Okay, and
as well?
again, preserving that we don't believe there was any agreement to pay a finder's fee, but as it's alleged, we're assuming the facts as they contend them.
Right.
Okay. They contend that they needed to bring in an additional buyers to preserve this real estate transaction. They talk about a case where they say, well, but a finder's fee was paid when they came in and bailed out a savings and loan and bought some of the shares. Well, savings and loan isn't subject to the statute of frauds. This transaction is, because what was the subject of this transaction? Buying real estate, and that's what the statute holds
But is
here.
the subject of the finder's fee transaction real estate?
Yes, it was to purchase real estate,
So
yes.
explain that to me, your reasoning on that.
Okay, so the Stevensons were brought in for one purpose, because they had the financial means to close this transaction. There'd been an appreciation during this time in the real estate market, so the original buyers had an incentive to somehow get this closed. So they brought in the Stevensons, and the joint venture was never workable, was never something that went forward. What happened was a double escrow on the same day. The Stevensons purchased real estate, and they signed an agreement identifying that in this transaction, which I guess is really two, that Mr. Nguyen represented them. And that's the disclosure
What's the
statements on the
difference
record.
between, you just said the joint venture didn't take place, but it actually did. It actually, the Stevensons did hook up with the original buyers, and they were able to complete the exact transaction that when brought to them as what their profit was going to be. So you're saying that it didn't effectuate from a formal joint venture contract to do exactly what happened. You're saying, yeah, there was no joint venture contract, or there was no agreement to have a joint venture, and yet the effect of them being brought together was exactly the opportunity that appellant's client brought to your client, was join in with them however you do it. Whether you take over the sale, whether you have a joint escrow, however it is, there's $100K out there to get. They can't get it on their own. You could profit from this. That's the opportunity that when brought to your clients. How it was effectuated, I don't know that it matters for a 12B6. It's just that when you say so affirmatively, there was no joint venture agreement, so they did it this other way. They did it the other way to effectuate exactly the opportunity, and that's what appellant is saying, exactly the opportunity that they were bringing to your client happened.
Okay, but the opportunity, this is the important point.
Okay.
Even if I concede that, and there's some nuances that I don't quite agree with, but I understand your central thrust. The opportunity was to purchase real estate, and that's why it falls within the statute of fraud. The opportunity, as you described it, as they described it, as everybody looks at this, was to come in and purchase the real estate in this
I
instance.
thought the opportunity was to make money.
No, they purchased the real estate. The risk was upon the
That's what
Stephensons.
led to them making money.
Yes.
The
but
actual opportunity that he brought to them wasn't real estate.
It was a real estate purchase. There was a particular piece of property that was being sold for a particular amount of money. It was a real estate transaction that they were brought into, and that was the opportunity to be in the real estate transaction.
Could they have done it different ways, though? I mean, could they have signed a contract with the original buyer saying, we're going to give you $80,000 to close this deal, and then once you do, you're going to sign a deed over to us? I mean, they could have effectuated becoming the owners or being part of the people who were going to benefit from the resale of this home in many different ways. It looks like they chose to do a simultaneous escrow. That was the way they were effectuating it. But couldn't they have done other things? Isn't that where we step back and say there was an opportunity and it was for them to do? When was it involved in how that all worked out? Everybody is saying that. It was up for the Stephensons and the original buyers to figure out how you're going to make this work so that the Stephensons can then be part of the profit of reselling the house.
Okay. The part I would say on this is any real estate transaction involves an opportunity to make money. That's why you get involved, is the expectation, particularly if it's not your home. Every other real estate transaction, there's an opportunity to make money, in fact, an expectation that you'll make money.
Yes,
that doesn't take it out of the statute of frauds.
typically the agent is being hired to list a home or to participate in the purchase of a home directly.
And
There's an employment agreement happening there.
And he had an employment agreement with the original parties, and then the parties signed off and disclosed that also included them. So there's no dispute about that. But the opportunity to purchase real estate is inherent in every real estate deal. And that if you hold that the opportunity to purchase real estate takes it out of the statute of frauds, you've rewritten the statute. You've said, no, we're not going to apply it to real estate because there's an opportunity to make money here.
So, counsel, if we adopt your position, will every finder's fee always be subject to the statute of frauds?
No, only if it relates to a real estate transaction. Then that's what the trial court held correctly. So if you do
So even if we have the agreement is that it's more long-term agreement, not based on every single transaction. So the agreement says that for the period of 5 years, I'm going to go out and find you real estate that you can make money on. That is always going to be subject to the statute of frauds.
Yes, and also because it's longer than 1 year, which would, any contract longer than 1 year would be subject to statute of frauds. But the statute of frauds is
for 1 year, right?
Statute of frauds isn't really a problem. It is a safeguard that protects both the realtor and the purchaser so that things are put down in writing so that you can't have these lawsuits that are about alleged oral deals. It protects the public. And if you're going to be involved in selling real estate as a licensed realtor, you need to comply with the rules. And the rule here is simple. Get it in writing. And he knew it and he didn't do it.
Isn't the point where 441017 applies, didn't it apply to the contract the buyers and Nguyen signed saying that Nguyen would represent them in the transaction? Isn't that where the agreement is under 441017, not the separate agreement between Nguyen and Stephenson's? Because it says, upon an agreement authorizing or employing an agent or broker to purchase or sell real property or mines for compensation or a commission. Isn't that where the statute of frauds
But two things can be true at the same time. It applies to both.
But I thought we just said this is two separate transactions. So
But it
there's the commission.
applies to, again, assuming there was such a finder's fee. But it applies to both. It applies to both. And he brought in two different parties at two different times, as counsel stated, to purchase this real estate. And if he wanted to get a commission from the second party that was more than what had already been agreed to, you put it in writing, and he didn't do that. And that protects everybody, including the courts, from these lawsuits about made-up finder's fees. That's the protection that my client gets from that statute of frauds.
If Nguyen wasn't going to be a party to the joint venture, why did that need to be in writing? I understand he's trying to get the finder's fee from that, but the agreement wasn't to purchase real estate. The agreement was for two parties to find a way to make something financially work that happened to be real estate. Nguyen wasn't involved in what was going to be going on between the Stephensons and the original buyers. He was wanting a finder's fee. If those two parties had a meeting of the minds and came to an agreement and it worked, he wanted to be paid something, but he wasn't a party to this kind of second transaction, right? This joint venture. If you say it's a joint venture, he was saying, if you guys actually get together and have a joint venture, I want a finder's fee from that. I don't need to know how you do it. I'm not a party to it. I can't bring any weight to bear on what the terms are. But if you two work out terms, I get a finder's fee. The end. If you don't work out terms, I don't get a finder's fee. The fact that it had to do with real estate, it's not a real estate transaction, it's a joint venture. I mean, isn't that their argument, that this isn't about real estate, this is about making a separate business agreement between two parties that Nguyen's not even a part of?
Essentially, I think that's very close to what their argument is.
Right.
But the second transaction that you're talking about, that simultaneous transaction, is a real estate deal.
Well,
it
that's
is a
not
pure real estate
But
deal.
you see, I think we're having, and I want you to explain it, because you keep calling the second transaction the simultaneous close, and I think that the way appellant frames it is the second transaction is whether or not there was a joint venture, that's the focus. And so we're kind of talking across each other.
I'd call that the third transaction,
Okay.
the alleged third transaction,
Right.
which never really happened. But the allegation is that he brought them in as purchasers for real estate. And that's repeated in this complaint, and the judge correctly focused on that.
Okay.
And if you're going to bring people in for a deal on real estate, yes, you have to comply with the statute of frauds. If you're selling loans, you don't have to, or savings and loans.
But is bringing people in authorizing or employing them?
Well, they're alleging they were employed to get a finder's fee. They're alleging they were employed. That's their
I
allegation.
realize that, but under the statute of frauds, it says upon an agreement authorizing or employing. So my question is your position that he was authorized or employed? Because that's what gets us into the statute of frauds.
The part before that in the statute says that in order to be able to collect on the following condition, in other words, in order to collect a commission, you have to comply in these following conditions, and this is number 7 of those different conditions that you can have. So they're the ones alleging that there was an agreement, which is why it's sometimes hard for me to address it. I don't think there was. But assuming that there was an agreement, then the answer is yes. There was an agreement. They're claiming there was an agreement for the Stephensons to come in and purchase this, and that he's the one that was responsible for getting them to agree to come in and save the day. And he may very well be right on the fact that he brought him in to save the day, but it still is a real estate transaction.
Okay, thank you so much.
Okay.
Okay, I just wanted to clarify that our position is that it was a joint venture agreement. We attached a joint venture agreement that was drafted by the Stephensons to our amended complaint because initially they said, you're crazy. There was never a joint venture. So we found it is unsigned, but it was prepared. And paragraph 1A says this will be a joint venture with 50% interest by each party. So there was a joint venture. Whether they signed it or not is not material. You can have an unsigned joint venture agreement, and they operated under the terms. So the joint venture involved real estate. The question is, what if the joint venture involved buying and selling cars? Would this be totally enforceable? What if it was to buy stocks, buy and sell stocks? Would this joint venture be enforceable? I think the answer is yes. And so does it change simply because the subject matter of the joint venture relates to real estate. I think opposing counsel was saying that the rule should be statute of fraud applies if it relates to real estate. I mean, it's a very broad term. In what way? You know, in Swingle, what if the savings and loan owned real estate? So when he bought 51 or 62% of whatever it was, you know, technically he was buying real estate indirectly. You know, would that make it subject to the statute of frauds? I just think the statute of fraud needs to be interpreted as the legislature wrote it. I think there's a danger in being overly broad with putting more agreements into the statute of frauds, simply because it can allow for fraud. It can be used as a sword and not just a shield. So, yeah, paragraph 7 talks about employing an agent or broker to purchase or sell real property for compensation or commission. And we believe that this joint venture, connecting people for a joint venture, does not fall within that narrow wording in paragraph 7, so the statute of frauds would not apply. If the statute of frauds doesn't apply, then all the case law relied on by the court, the trial court, doesn't apply, and the case needs to be remanded.
So you want us to separate the language in the final contract that said that your client was employed by the Stephensons to sell real estate, which is a document they all signed, from the joint venture that's alleged in the complaint, and that he wasn't employed by them to transact real estate?
Well, for the limited purpose of the adding them onto...
Right, but aren't you conceding them that he was employed by them for a real estate transaction?
Well, not for the matching up of the joint venture. The only reason they got to the second part was because the first part happened.
Right.
The joint venture happened. If there was no joint venture, there would be no second part.
Okay.
So...
Thank you. Any other questions?
All right, no.
Thank you very much, both of you, for your arguments this morning. We'll take the matter under advisement and issue a decision in due course, and we'll stand in recess to reset for our next argument.